First of all, I would like to welcome all of you, participants in this event on Gaza at the ICJ, organized by and at the International Institute of Social Studies in The Hague. And of course, I welcome you here in person in the room, but also many people that are joining us online through the live stream. My name is Karin. I'm Professor of International Law and Development and Deputy Rector for Educational Affairs here at ISS and co-convener of this event together with my colleague, Associate Professor in Legal Sociology, Dr Jeff Handmaker. We are here to exchange first views on, well, what definitely in the perspective of lawyers, but probably of many others as well, are the exciting legal events that have taken place around the corner from this building, actually, yesterday and today, in the Peace Palace, where South Africa and today Israel presented their arguments in the case concerning genocide in Gaza. And this rare opportunity to seek an international judicial intervention in a contentious case on this matter has raised a lot of attention. And in a couple of weeks, the International Court of Justice has the opportunity to deliver a judgment that could make a difference. And the fact that there is, or at least potentially is, something important at stake here is expressed by the enormous level of attention for the case in the media, among lawyers, diplomats, and other professionals, activists, and others. And I think it also shows in the number of people that participate in this event, in this room, but also definitely through the live stream. As an academic institution, the ISS cherishes the opportunity that this event today and the presence of a large number of experts on the issues involved provide for a comprehensive and multidisciplinary analysis of the case, the arguments exchanged, and its potential implications, legal and otherwise. And it is clear that the case, the devastating situation in Gaza, the effects in the West Bank and the state of play of the Palestinian cause give rise to deep concern and tensions, also in academic communities like ours. And in that light, I reiterate our usual protocol. During all sections of this event, please make sure to listen and show respect to one another, engage with and respond to each other's arguments and ideas, and know that hate speech or ad hominem attacks on the person rather than on an argument, will not be tolerated. We look forward to an interesting and a fruitful exchange. And for a further introduction, I now hand over to my colleague, Jeff Handmaker.
So good afternoon. Again, my name is Jeff Handmaker. I'm, of course, working here at the ISS. I'm also an associate professor at the University of Witwatersrand in South Africa. And I say this because I'm actually very, very proud to have a long-time association with the Republic of South Africa that so courageously brought this case before the International Court of Justice. Thank you. So yesterday and today, the International Court of Justice has been holding hearings in a case brought by South Africa that accuses Israel of genocide in the current war in Gaza, which erupted in October 2023. And I say current war because there have been multiple wars over the past 75 years following attacks in Israel by the militant group Hamas. South Africa is seeking provisional measures from the court, and in particular, an immediate suspension of Israel's military campaign. All states that have ratified the Genocide Convention, which include both South Africa and Israel, are obliged to not commit genocide and also to prevent and punish genocide. The treaty defines genocide as acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group. As we heard during the ICJ proceedings, the war in Gaza has a context. Despite Israel's withdrawal of settlements and redeployment of forces in 2005, Israel has continued to occupy the territory of Gaza It has continued, indeed, to occupy the territory of Gaza continually since 1967, including a siege on this 365 square kilometer piece of land, severely restricting basic needs. The majority of Gazans are under the age of 20 and have never left the territory. The vast majority of the inhabitants of Gaza comprise refugees and their descendants, forcibly displaced from their homes in 1948. I was very pleased to hear this articulated during the ICJ hearings. They have, of course, been under United Nations protection ever since. This is not the first time the ICJ has intervened in the long-standing impasse between Israel and the Palestinians. In 2004, 20 years ago, almost to the day, the court issued an authoritative advice on the implications of Israel's wall in occupied Palestinian territory, declaring it to be illegal, and also stating that all states are under an obligation not to recognize the legal situation resulting from the construction of the wall and associated regime, not to render aid or assistance in maintaining the legal situation, and this is very important considering what we are confronted with now, to ensure compliance by Israel for atrocity crimes. In the meantime, also, the International Criminal Court is not just the ICJ is not the only apex court here in The Hague. There's also an ongoing criminal investigation by another apex court, the International Criminal Court. The ICC has jurisdiction over several international crimes, atrocity crimes, including war crimes, such as the deliberate killing and starvation of civilians without justification, and crimes against humanity, including apartheid and genocide. Already in October, hundreds of scholars with expertise in international law, Holocaust and genocide studies, and later UN experts called on states to prevent the commission of genocide already in October. The case brought by South Africa now puts this matter firmly in the public domain, with an eye to ending the genocide and ultimately seeking accountability. This is the legal team that argued the case before the International Court of Justice. Karin, do you want me to introduce the speakers briefly, or do you want to take that? Okay, I will introduce them briefly because there's also been a change to the program. First of all, we're going to hear from Dr. Giulia Pinzauti. Dr. Pinzauti is an assistant professor of international law and a researcher at the Crotia Center for International Legal Studies at the University of Leiden. Dr. Pinzauti will address arguments that have been posed by the legal teams representing South Africa and Israel. Next, we'll hear from Sahar Francis. Ms. Francis is General Director of Adamir Prisoner Support and Human Rights Association, a Palestinian NGO based in Ramallah. Ms. Francis will address the relevance of the ICJ court proceedings to what has been experienced on the ground in the West Bank and within Israeli detention centers. Next, unfortunately, we cannot be joined by Mr. Raji Surani, who has nevertheless been here in The Hague following the proceedings very closely. Indeed, he was also an advisor to the South Africa legal team at the ICJ. We are very privileged to have with us also Ahmed Abofoul. Ahmed Abofoul is legal officer with Al-Haq, another one of the key human rights organizations in Palestine. He's also, I'm very proud to say, a research fellow here at the International Institute of Social Studies. Mr. Abofoul will address the relevance of the ICJ hearings to what has been experienced on the ground in Gaza. Coming from Gaza, you're very well positioned to address this. Thank you very much, Ahmed, for stepping in at such short notice. And finally, we have Ms. Katherine Gallagher, renowned international human rights lawyer with a Center for Constitutional Rights in New York. The CCR recently filed suit under the against the Biden administration in the United States for complicity in genocide. Ms. Gallagher will address the potential consequences of the ICJ's judgment for what may happen at the global level and in relation to third states.
Thank you, Jeff, and thanks, Karin, for organizing this event. I'll present the arguments of the parties before the court, but first of all, just a couple of words on how did we get there. South Africa instituted proceedings against Israel on the basis of Article 9 of the Genocide Convention. The court's case law establishes that all state parties to the Genocide Convention have a legal interest in ensuring that the obligations in the convention are complied with and can invoke the responsibility of another state party, even if they're not specially affected. So this is how South Africa brought the case. In its application instituting proceedings, South Africa argues that Israel violated the Genocide Convention by committing genocide against Palestinians in Gaza and by failing to prevent it. In addition, it didn't hold senior Israeli officials and others accountable for their direct and public incitement to commit genocide. I think it's important to say that South Africa unequivocally condemned the targeting of civilians by Hamas and other Palestinian armed groups that happened on October 7th and the taking of hostages. However, the argument is that no armed attack, no matter how serious or horrific, can justify violations of the Genocide Convention. While the ICJ case may take years to reach a ruling on the merits, South Africa asked the court to order provisional measures. These are urgent measures that are needed to protect the Palestinian people in Gaza from further harm, ensure Israel's compliance with the convention, and safeguard South Africa's ability to have the case fairly adjudicated pending resolution of the case on the merits. There are 5 conditions for the ICJ to indicate provisional measures. That the court has prima facie jurisdiction, that there's a link between the measure requested and the right of the parties. Third, plausibility of the claim on the merits. And fourth, risk of irreparable prejudice. And fifth, urgency. So I'll just briefly go through these main points. The standard for the court to indicate provisional measures is lower than that applicable at the merits stage. So South Africa only needs to establish that the court has prima facie jurisdiction. It doesn't need to prove that Israel is committing genocide, but it suffices for South Africa to establish that the acts complained of appear to be capable of falling within the provisions of the Genocide Convention. In other words, it needs to show that the Genocide Convention is somehow implicated by Israel's conduct. And here, South Africa argues that there is a plausible claim of genocidal acts through mass killings of Palestinians in Gaza. We know what the numbers are. The infliction of serious bodily and mental harm on the Palestinian people through injury and forceful displacement. Conduct calculated to bring hunger, starvation, dehydration, and the spread of diseases. And finally, the imposition of measures intended to prevent birth within the Palestinian group. According to South Africa, these acts are carried out with genocidal intent, the intent to destroy the Palestinians from Gaza in whole or in part. And this intent, which is very difficult to prove, is evident from the way in which the attack, the military operations are being conducted, for example, by the use of extremely powerful weapons in a densely populated area like the Gaza Strip. In addition, Israeli political leaders and military commanders have declared explicitly the genocidal intent through the use of dehumanizing language. And there are many examples of these. We're fighting human animals and the like. And these statements have been repeated by soldiers on the ground. The fact that Israel may have other motives for its military operation, for example, fighting Hamas, doesn't save them from a finding that they also possess genocidal intent, South Africa says. Another condition for the court to have jurisdiction is that there is a dispute between the parties at the time of filing of the application. South Africa argues that a dispute exists in that it repeatedly and publicly voiced its concern that Israel's act had become genocidal in multilateral fora such as the Security Council and the General Assembly, and also sent several diplomatic notes to Israel. There were no negotiations between Israel and South Africa on this matter, but none are required under Article 9 of the Genocide Convention. South Africa then made a compelling argument that there is an urgent need for provisional measures to prevent further irreparable harm. Gaza is being wiped from the map. Each day, on current rates, hundreds of people are killed, the majority of whom are women and children. Each day, hundreds of residential homes are being destroyed and people are literally starving. The situation couldn't be more urgent. The legal team also recounted recent examples in which the court indicated provisional measures, for example, in the case of the Rohingya people or in the case brought by Ukraine against Russia. And in those circumstances, the circumstances were no more compelling than those existing in Gaza today. South Africa requested the court to indicate 9 provisional measures. The first 2 aim at the suspension of Israel's military operations, as Jeff was saying. And the idea is that if a military operation, even if it's in compliance with IHL, which is a big if, is conducted with an intent to destroy a protected group, this military operation must stop. Under the third measure, both Israel and South Africa must take all reasonable measures to prevent genocide. And in particular, the Israeli government is bound to prevent and punish others who engage, incite, or support conduct that violated the Genocide Convention. South Africa also requested the court to order Israel to desist from committing genocidal acts and from the imposition of conditions of life that are calculated to bring about the destruction of the Palestinians in Gaza. Importantly, South Africa asked the court to indicate that Israel must take effective measures to prevent the destruction and ensure the preservation of evidence and allow access to fact-finding missions and international bodies for this purpose, and also asked the court to impose on Israel some reporting obligation. And finally, the team asked the court to order Israel to refrain from actions that could worsen or prolong the dispute before the court, making it more difficult to resolve. The team didn't ask the imposition of any measures against Hamas because Hamas is not a state and it's not a party to the proceedings before the court. Anticipating that Israel would invoke its right to self-defense, South Africa argued that in the Wall Advisory Opinion, the court already held that Israel cannot claim a right of self-defense in relation to a threat that emanates from a territory that it occupies. And despite the disengagement in 2005, the Gaza Strip is still occupied territory. And as was recognized by the Security Council, and therefore the right to self-defense under the UN Charter has no application. Coming now to Israel's argument, we heard a very different story this morning. Israel asked the court to reject the application for provisional measures and remove the case from the list. It said that South Africa presented a distorted factual and legal picture. If genocidal acts have been committed, they have been perpetrated by Hamas against Israel on the 7th of October, and Israel resorted to the use of force to defend itself and its people, using its right to self-defense. Israel's argument, as I understand it, has 4 main prongs. The first line of defense was to say that the court lacks jurisdiction because there is no dispute and because the acts complained of do not fall under the remit of the Genocide Convention, but were committed in an armed conflict. There's no dispute because South Africa decided that a dispute existed unilaterally and foreclosed any options for an amicable resolution of this matter. This is not a dispute, Israel said. It is a one-sided unispute, quote unquote. The acts complained of do not fall under the purview of the Genocide Convention. They were committed in the context of an armed conflict instigated by Hamas. And an armed conflict, even when it's justified and conducted lawfully, costs lives. And this is particularly the case when there is a terrorist organization that is intermingled with the civilian population. So damage was caused by the Israeli Defense Forces in the legitimate pursuit of military objectives, but much of the destruction caused in Gaza was actually caused by Hamas, that is booby-trapping buildings, placing mines, and using rockets that misfired. Second prong of the argument is that South Africa failed to meet the condition of plausible rights. The intent to commit genocide is not even a plausible inference on the evidence. South Africa, according to Israel, only showed random codes that are not in conformity with the official government policy. The official policy is that this is a war against Hamas, not the people of Gaza. The IDF is doing its best to minimize civilian casualties, for example, by issuing effective warnings and evacuation orders in advance of attacks. But Hamas is doing its best to maximize civilian casualties by using civilians as shields. If there are soldiers that violated the law of armed conflict, they will be dealt with by Israel's robust and independent legal system. These are the arguments of Israel. And Israel is engaged in a humanitarian coordination efforts, so any charge of genocide in the face of these efforts is absolutely untenable. The third prong of their argument is that the standard of irreparable harm and urgency for the indication of provisional measures is not met. Israel has taken increasing steps to improve the humanitarian situation, and these steps have had an impact on the ground. So there is basically no urgency for the court to do anything. For example, bakeries reopened, they said. Moreover, the scope and intensity of hostilities has decreased. The campaign has shifted to a new and less intense phase of fighting. And Israel is implementing UN Security Council Resolution 2720 for the alleviation of the humanitarian situation. In the past, the court has deemed it unnecessary to indicate provisional measures when a government showed willingness to act in accordance with recommendations from the Security Council. Importantly, Israel's co-agent provided assurances that Israel is bound by international legal obligations, including those under the Genocide Convention. And they say that this kind of assurances rendered by state officials render the indication of provisional measures unnecessary, because South Africa would have the court say that they cannot trust the assurances given by Israel's state representatives. The fourth and final prong of their argument is that each of the provisional measures sought are unwarranted and prejudicial for one of the parties to the case and the conflict, Israel. In particular, the request for suspension of military operations in Gaza was highly contested. South Africa is not a party to the conflict, which is between Israel and Hamas only, and it's now asking the court to order only one party to the conflict in Israel to hold its military operations. This would thwart Israel's right to self-defense and impede Israel's operations for the rescue of the hostages. Provisional measures ordered by the court would not be binding on Hamas, as we know, and would end up furthering Hamas terrorist goals ultimately. South Africa's request for Israel to desist from its genocidal acts seeks, according to Israel, an implied ruling on the merits and should thus be refused. It would have the effect of tarnishing the reputation of the respondent. With regard to South Africa's request to prevent the destruction of evidence, there is no evidence that Israel is actually destructing evidence. If the argument is that the effect of the military operations themselves leads to the destruction of evidence, then this is de facto asking for a suspension of the military operations, which they already told us is unwarranted in this case. With regards to access by fact-finding missions, access from Egypt is under the control of Egypt, not Israel. And Israel has no obligation to allow access to its territory to fact-finding bodies. The request for reporting obligation is unnecessary in the present situation. It's a measure that is required only occasionally by the court, not routinely. And finally, the measures for the non-aggravation of the dispute are not the norm. South Africa doesn't justify why they're necessary. And again, they cannot be imposed only on one party to a case or only one party to a conflict.
Good evening, and thank you very much for inviting me to share tonight in this presentation. Actually, it's a historical days for us Palestinians, for freedom fighters, for lawyers who were waiting for, like myself, like for more than 25 years working with prisoners and trying to seek justice locally and internationally for victims of torture, arbitrary detention, unfair trial procedures, and all what the prisoners suffered from systematically for decades. I know that maybe for like the issue of the prisoners wouldn't be totally connected and could understand under the provision of the genocide now, but it's relevant and it makes sense when South Africa included in their case a part about the issue of the prisoners and all the practices that the prisoners from the Gaza area especially faced since the 7th. But I wanted to highlight in front of you that it didn't started on the 7th of October. It's good that now finally someone in the international level decided to open the door for us through the South African case in order to hear our voices. But it all started in 1948 and even before, and it all started with this colonial regime that is imposed, and the law system and the justice system that the Israeli representatives were proud about today in the session is the main tool of the system of colonialism to oppress, to control, to maintain the oppression over the Palestinian people for more than 75 years. And the issue of the prisoners is just one example of how the state were weaponizing legal systems, laws, in order to maintain the control. So all what we will describe as torture, arbitrary detention, military court system, honestly, you can tick all the list of grave violations of the 4th Geneva Convention as war or the Rome Statute that falls under war crimes and crimes against humanity that the Palestinian prisoners experienced in the Israeli prisons and in interrogation centers and so on. And they are always getting away without any accountability with these arguments that we heard today, that this is for security reasons, it's justified because these people are terrorists. There is a necessity. Mr. Barak, who sits today on the panel with the 15 judges in the ICJ, he is the same judge who ruled about the torture cases in the Palestinian context to give a green light indirectly to the Israeli security service to torture and to run away without any accountability with the necessity defense. And when he said that they can use the ticking bomb scenario. And this is why torture is being implemented even today, and in more severe ways than what we were documenting in the 90s and in the 2000 and after. And this is why it's very, very important and essential for us, such kind of cases, whether on the ICJ or the ICC, or exhausting the universal jurisdiction procedures, but it's not enough. Because we are not fully have the trust that it will work. And what if the court decides negatively? I don't want to be but this could be, and this is one of the scenarios that we have to be prepared for as activists, because this is why I'm really grateful for your coming today in order to discuss and to be aware about that we have duty as activists, as people who share the values. And if we want to keep our humanity and our standards of human rights equally everywhere and for everyone, we have to see how this system works, the international system. It's the exam of the ICJ and the ICC. The Palestinian case is the test for them, if it can work for us, or it was designed for the North, for some categories, and never for Palestinians and others. I know maybe I made a long introduction, but for me, it's more important that the details, and I avoided doing a presentation with images because I assume all of you saw the very humiliating, degrading treatment that the Palestinian prisoners especially from the Gaza Strip, faced in the last 3 months. It's unbelievable, the amount of hate and how it was visible in the treatment of the prisoners, and not just in the Gaza Strip. Maybe the most extreme scenes happened in the Gaza, but it was continuing, and it's continuing before the 7th and after the 7th in the West Bank, in East Jerusalem, and now even inside Israel. And this is what was a bit surprising, actually, how they were able to immediately not just arrest more than 4,000 Palestinian workers from Gaza, that they were working inside Israel with permits, to lock them down and to start to launch mass arrest campaigns in Jerusalem, in every city and refugee camp in the West Bank, immediately on the 7th. And in the same time, amending all the civil laws and the military orders relevant to the issue of arrest in order to enable the judges and the courts and the police to have more time. Like, instead of arresting someone and bringing him within 8 days or 4 days to the military court, now it's 8 days. Instead of issuing the administrative detention order within 8 days, it's 12 days. The interrogation, instead of finishing interrogation in the civil system, 35 days, and this is applicable for the prisoners from Gaza, it's now 90 days. They were like, how they managed to change the whole legal system in one night on the 7th and started to practice immediately, because they were doing this for decades. It happened in the first Intifada, in the second Intifada, and it continues today. So currently there's 8,800 Palestinian prisoners inside the Israeli prisons, not including the Gazans, because literally the Palestinian prisoners from Gaza are disappearing. There is the category of the laborers that they were arrested. Most of them, we believe that they were released back to Gaza in the middle of the war, but we don't know, and we will never know how many are still in detention and in which legal capacity, because some of them, they could be under illegal competent law. This is a very unique frame for the Israeli legal system. In the international system, there's either civilians or competents. There's nothing like illegal competent. It's a Israeli invention that was decided in 2002 and used against internationals, Lebanese at that time, and now against Palestinians. And guess what? They enabled the courts to arrest some, even at the beginning, they have the 45 days in order to issue the warrant arrest. So they grabbed people from Gaza without any judicial procedure, and they are sitting there for 45 days incommunicado because there's a denial on lawyers' visits for up to 188 days. 6 months denial of lawyer visit. What kind of judicial system is this? Why we should have a judicial system? When they issue the order after 45 days, they have 75 days to bring you to the court, and they can bring you to the court without the presence of your lawyer. For what? What you will argue about the secret information. And the detention is indefinite. It's not limited. They can keep you forever under the illegal competent. They have to review the order every 6 months. All these detainees that they were classified, and they are thousands, because we don't know the exact number, as illegal competent detainees, they were never visited. We don't know if they are doing the legal review for them or not. Those who were arrested on the 7th and the 8th, and they were brought to interrogation, the same story. We don't know how many they are interrogating. At least we know there's 2 interrogation centers, Beit Tikva and Be'er Sheva. And again, they amended the procedures. So the lawyer's ban on visit is up till 90 days, 3 months, under interrogation with the severe torture that we know. Israel is not hiding that they are using moderate physical pressure. They call it moderate physical pressure. We exactly know the techniques that they are able, and I'm sure now they will develop new techniques. And what we know that 7 prisoners already died in the Israeli prisons out of brutality, violence that was imposed by the Israeli police. So you can imagine those under interrogation suspected to be involved in what happened in the 7th of October, which kind of physical torture they will be facing, and without being able to have medical support, like any medical services as well. Since all these thousands of prisoners since the 7th of October, they are subjected for very severe life daily conditions. The prison authority cuts electricity, water, minimized the food starvation policy also inside the Israeli prisons. And this is why these 7 prisoners died out of physical attack, of health neglect. At least in one case, one diabetic prisoner, after 3 days of his detention, he collapsed and died because he was never receiving his medication after the arrest. The increase in the use of arbitrary detention, administrative detention, this is very similar to the illegal competent law, but it's used in the West Bank. It increased from being 1,200 before 7th of October. Currently, it's 3,300 administrative detainees, including children. There's more than 20 children are subjected in administrative detention. Since the 7th of October, more than 355 children were arrested and 184 women. This is not related to the exchange deal and all these photos that we saw that children were released or women were released. No, it doesn't mean that they all were released. They're still arresting more and more. People are sleeping on the ground with a very thin mattress, very cold. The windows are open because they took the cover from the windows. The humiliation and the degrading treatment for the prisoners, we never experienced such. And it was very clear policy from the Israeli Minister of Interior Security Affairs responsible for the prisoners, Mr. Ben-Gvir, that he said it clearly. He will make their life hell. And this is why I think the International Criminal Court, at least, have a duty, have a role in order to stop all these by issuing warrant arrests in such very clear violations for the international law, and it falls under their jurisdiction when it comes for torture, ill treatment, arbitrary detention, transfer of prisoners into the occupied territory, because all the prisons are located inside the state of Israel. So clearly we can use the international law in order to stop these crimes. We need the intention, we need the political will from the states to take their responsibilities according to the 4th Geneva Convention and find perpetrators accountable. When Ben Gvir coming to Holland, he could be arrested for these crimes if Holland wants to prosecute him for these crimes. Thank you.
I'm an attorney in the United States at the Center for Constitutional Rights, and I'm speaking on this panel today in large part because of the significant role of the United States in enabling and furthering the genocide that was discussed today at the International Court of Justice. In our capacity at the Center for Constitutional Rights, we have been warning from the very start of the risk of genocide and highlighting the duties on all states, frankly, under customary international law to take action to prevent genocide, and warning of the potential to slip into the criminal act of complicity in genocide. On October 18th, CCR put out a legal and factual briefing paper because what we were seeing as genocidal statements, as admissions of action plans for genocide, were being made at the most senior level of the Israeli government by the president, by the prime minister, by the minister of defense, threatening to destroy the Palestinian population in Gaza and to have no food, no fuel, no electricity, and no water, to upgrade the 17-year blockade that had already existed and made the Palestinian population in Gaza particularly vulnerable, to upgrade that to a total siege, as we saw that declaration of an underlying act of genocide, namely the deliberate infliction of the conditions of life to destroy a group physically in whole or in part. What we saw the United States do was promise its full and unconditional support to genocide. We saw the President of the United States, Joe Biden, fly to Israel, stand shoulder to shoulder with Israeli officials. We saw the Secretary of Defense, Austin, fly to Israel and promise that anything that was needed would be provided. We saw the Secretary of State, Antony Blinken, travel and again make these same promises while reporting out we are in contact with Israeli officials on a daily basis, even an hourly basis, and we will give what is needed to respond. Again, we hear the terrorist frame employed continually. We will give what's needed for this defense. And what the United States has given is unconditional military, financial, and diplomatic cover to a genocide. So again, in the middle of October, our briefing paper laid out the factual basis for a case of genocide by Israeli statements, followed by actions, and corresponding actions and statements by U.S. government officials. We sent that with the legal analysis of the duty to prevent genocide and warnings again about the complicity to genocide to President Biden, to Secretary of State Blinken. We sent it to the U.S. Ambassador to the UN, and we said, take action now. And instead, what we saw was the U.S. veto a ceasefire resolution and continue to rush weapons to Israel. So on November 13th, I'm profoundly moved and honored to be here today with some of our plaintiffs. We filed a case on behalf of Defense for Children International Palestine. Of course, this has been a genocide that has seen just a huge number, a devastating number of children killed and so many children whose lives are now at risk from starvation, and al-Haq, including Ahmed, who has put in a declaration. The organization has put in a declaration, and I think he'll speak more personally maybe about the losses that he has endured, as well as 8 individual plaintiffs, 3 of whom are Palestinians in Gaza right now, and then 5 Palestinian Americans. And so we put in a complaint against the senior U.S. officials, Biden, Blinken, and Austin, charging them with 2 counts: complicity in genocide and the duty to prevent genocide. And we have then followed that up with a preliminary injunction motion, which is actually quite similar in its framework to a provisional measures request at the ICJ. We are asking the court to, at least as the merits of this case are adjudicated, to put in place an injunction that enjoins the United States from continuing to send weapons to Israel that we know, that are documented, to be used against Palestinian civilians in indiscriminate attacks and to maintain the total siege on Gaza. So those filings went in about 6 weeks before the South African application. The United States responded to our brief on December 8th with a motion to dismiss the case. And on that same day, which was right after the pause happened, what the United States did at the end of that pause, it vetoed another ceasefire resolution at the Security Council. And it rushed another $106 million worth of weapons, artillery shells being used in indiscriminate ways to Gaza. So that is what the United States did as an action while moving to dismiss our case. The United States argued that the defendants argued that this case should not be heard by a court, that these are political questions. It's up to the executive branch to decide what it wants as policy towards Israel after October 7th. And we have argued that genocide cannot be a policy choice. It is a question of lawful or unlawful conduct, and it is for the courts to determine what the law is and to hold everyone to account. It's frankly quite similar to what we heard in regard to the arguments around self-defense, that somehow there is an exception to the prohibition on genocide because of self-defense. We followed up our arguments with amicus briefs that went in on behalf of a number of human rights organizations, by Jewish Voice for Peace, by journalists, by medical doctors, all warning again about the genocide that exists. And we also had a declaration from Josh Paul, who is a State Department official who has resigned in protest because of the way U.S. policies around arms to Israel in support of this genocide have played out. We will have an argument on January 26th in California. I should also note that we had an expert declaration by William Shabbos, who is a name that is known to many people in this city, who declared that already at the beginning of November, the United States was in breach of its duty to prevent genocide because the United States has unparalleled influence on the practices and policies of Israel. Now, we only asked him to opine on the duty to prevent. If you look at what the United States has done, we've argued that it crosses the line from that failure into actual complicity. And it's in compliance with, our arguments are in compliance with international law out of the ICTR, out of the ICTY, providing weapons, procuring the means by which genocide is committed is complicity in genocide. So we will see what the judge decides at our argument on January 26th. And whatever comes out of the ICJ, I think already the fact that there was an application that went in shows what the UN officials have been warning about, what humanitarian organizations and human rights organizations have been warning about, and what the facts on the ground show. And that is that there is, at minimum, a serious risk of genocide. And so the United States already has had obligations, and it is in breach of those obligations.
It's an honor to speak. Replacing Mr. Rajesh Rani is a big shoe to fill, and I'll do my best. And thanks to the speakers whom I'm honored to be with on the panel. They all have been great examples, whether for their human rights work in Palestine, like Sahar, or Katie, who's doing an amazing job, or Giulia, whom I was one of her students. So it's extremely an honor for me to be here. I was asked to speak on Gaza perspective, and I intend to approach this a little bit differently. We often think of the situation in Gaza and we expect a human story from Gaza, but to be honest, as Gazans, we couldn't care less of the West interest of a human story. In a way, Gaza is, or Palestine, the Palestinian cause, is your window to learn the reality of the world we live in. Because unlike how certain powers in this world wish to believe or actually behave, the past months have shown us clearly we don't live in a post-colonial world. Rather, we live in a neo-colonial and an imperial one. We don't live in a world where we enjoy all and the same human rights, but there are double standards. It depends on where you're from and who's your oppressor. Certain states will take positions, and here clearly I refer to the hypocritical, shameful and disgraceful position of certain states, especially in the West, including the Netherlands, the US, and several other powers that have been speaking passionately for the past at least 2 years, and much more about human rights, the importance of international law, the importance of justice, and we thought it's actually good. It's important. That's how things should be. But then, when the situation is about Gaza, this conversation seems to change. Then we talk about security, peace absent justice, and then it tells you all you need to know about how these states view our part of the world. And I think our part of the world, and I don't only mean Palestine here, I mean the global South, if it has one message to convey to this part of the world, is to tell it that we're not colonial objects. We're people who have their rights, their convictions, their aspirations, and would like to be treated equally. Unfortunately, those quote-unquote liberal democracies who claim to promote human rights and international law, although had the full opportunity and the full control of the world, and I think the chance to implement that body of law that they claim to adhere to principally on everyone, they failed to do so. And that's why international law as a body, as a whole, was put into question. And I think the past 2 days, in particular yesterday, starting the hearings, South Africa has taken the initiative principally to teach these states that have been lecturing about international law what true leadership is like, what principal application of international law is like. It also represents, I think, much bigger than that. It represents that the global South is fed up with Western hypocrisy and taking things in their hand. International law, with all of its shortcomings, is better than nothing, but it's also not the product or the property of a certain part of the world. It's the law. It's the law that must govern us all as equal human beings. It's the lessons of two destructive world wars that happened in Europe, where human suffering has been immense. And we should have learned the lessons. I mean, the West should have learned the lessons. After all, in all honesty, the racist ideologies that resulted in such human suffering, they originated here. I'm sorry, but let's be honest. I want to speak frankly as someone from Gaza. Neither Nazism nor fascism or even Zionism originated in our region. We have always lived in coexistence. Muslims, Christians, Jews, believers, not believers, in all shapes and colors. Especially Palestine was actually, if one can draw the comparison, it was Switzerland of the world back then, where everyone lived in peace and harmony. We didn't even need an army because we coexisted. So I wanted to put this into context because what we're suffering in Palestine is not different from those ideologies. Zionism too originated in Europe. Zionism too is a form of racism and racial discrimination. And these are not my words. This is actually United Nations General Assembly Resolution of 1975, where the world collectively decided that Zionism is a form of racism and racial discrimination. This resolution was revoked in 1991, not because Zionism stopped being racism, but because it was an Israeli maneuver in order to come to the Madrid conference. Israel conditioned that this resolution will be revoked. And then it was revoked. This is an important moment of history that I wanted to highlight to bring things back to, I think, the fundamental issue we need to talk about. And why I'm saying this is because history has shown us that colonial ideologies have always been genocidal, in particular settler colonialism, because it's premised on the notion of space, on colonizing the land, and replacing the indigenous population. Now, I know some of the statements have been shocking because the Israelis are calling for genocide. But for those who don't know, please research and read the statements of the early Zionists. They were equally genocidal. Palestinians, since before 1948, were described, in the words of Binger and I think, as beasts walking on two limbs, or human animals, as it translates today. If you don't want to listen to a Palestinian, there's always a presumption that we cannot be objective, even if we hold all these degrees from European universities. But if you don't want to listen to a Palestinian, read Ilan Babé, The Ethnic Cleansing of Palestine. Listen to what our Jewish colleagues, who are principled with a clear moral compass, would say. Why I'm saying this is because, to put it in brief, when we call for solidarity with Palestine, to speak out for the injustices in Palestine, we don't expect that every and each one of us would free Palestine. Together we will. But Palestine is there to free you. When you align yourself with the struggle of the Palestinian people, with the clear moral compass there, you see the world for what it is. You're eliminated from this illusion that we live in a world where we're equal, where we pass this area where there is masters and slaves. Unfortunately, we have not. And it's our mission together to have this moral clarity in order to be able to move forward. And I think Gaza is teaching us all a lesson, and we should listen. We should listen carefully there. I was actually in New York last month, and I'm coming to what Katie touched upon, and the case that we started with our colleagues in the Center for Constitutional Rights, DCI, Palestine Defense for Children, and several other colleagues, where Gaza or Palestine is also putting these liberal democracies to test. Are they truly liberal democracies? Because what we're seeing here in the streets of Europe, that the majority of the people are saying no to genocide, but governments are supporting genocide. The vast majority of Americans are saying no to genocide. The vast majority of the Democrats are saying no to genocide. But there seems to be a disconnect between what governments are doing and what the people wants. And if there is a moment in history that is similar to this one, it's the last phase of the apartheid regime in South Africa. That's why this current case carries a moral weight. The South African knows the situation and know what the Palestinians are going through because they've been through it. They suffered colonialism, apartheid, and its racism. And that's why I think the moral compass is clear there, and we should listen to what South Africa is saying. On the U.S., and I want to say this as someone from Gaza, and I will tell a story. I was asked, how do I feel? And all Palestinians are asked, how do they feel? And I said clearly, I don't think anyone would ever understand how we feel, and we don't hope that any of you will ever have to understand how we feel. But I can put it briefly. I can say that I felt freer when I was in Gaza, when I was under the bombs. I felt more free than I'm here, safe, because those people, I think, with this difficult situation have gotten out of all of this facade of quote-unquote humanity that we seem to believe. On the U.S., you mentioned vetoes, Katie, and I think a message, if I can say from Gaza as a Gazan, is that our oppressors and their allies, they can have all the vetoes in the world and all international organizations they want, but they shall never have veto on our humanity. We have something in this world, and we will fight for it. And I think what Palestine is doing together, I think, and what also South Africa is doing, and the Palestinians insistent to recourse to law, despite the disappointment, despite that the world has failed the Palestinians, despite all of these states have failed and humanity has failed the Palestinians, especially in Gaza, are teaching the world a lesson that you will never have veto on our humanity, and we will keep recoursing to international law, and we have something in this world. We will fight for it, and we will show you the path, because you have been, in a way, misled. And therefore, I think I will repeat this message. We have to listen to what the Palestinians are saying and break through this mental barrier that has been created by these colonial and imperial powers, as the Palestinians, or as every native population, have been described as emotional, irrational. They don't know what they're talking about. It's completely the opposite. Your window to the truth is Palestine. Palestine is not there for you to free, it's there to free you, and continue to look there. And thank you very much. I stop there.
Thank you very much, all four of you, for very clear and powerful perspectives. Jeff and I will be at both ends of the room. We will collect, say, 3 to 4 questions at a time, and then we revert back to the panel.
I don't have a crystal ball to be able to predict what the court will say, whether the case that Israel presented will be able to tilt the court's decision into dismissing South Africa's submission. I honestly don't think so. I didn't find like 3/4 of the presentation by Israel very compelling on the law until maybe the last 2 speakers. They made some perhaps some good points. I do think that the court's jurisdiction is established on a prima facie basis, which is a lower standard than the merits. And I think that Israel did, put together the best argument to say that there is no dispute and that the acts complained of are not capable at all of falling under the purview of the Genocide Convention. But I think that the reality that we see, even from where we stand, thanks to reporting from Gaza, tells a different story. And I think that the judges will not buy into those dismissive arguments. Now, what I think might happen is that the court will not order all of the measures that were requested by South Africa. It might order some of them, or slightly different ones. For example, I have serious doubts that the court will order the suspension of Israel's military operations in Gaza, as was requested by South Africa. It is a measure that has been ordered in the Ukraine versus Russia case, but I think Israel's lawyers made good arguments on how these two cases should be distinguished, and I don't see the court going down that route. They may use some slightly vaguer or different language to encourage the parties to reach a ceasefire, for example. And they may impose some measures also on South Africa, for example, to use all the measures at its disposal, including diplomatic means, to put pressure on Hamas, which is something within their control, perhaps. So in short, I think and I hope that the court will not dismiss South Africa's request and will not dismiss the application, but it might order measures that are different from those that were requested by South Africa.
I might have found the arguments today a little bit less persuasive, in especially the last part. I think what we heard a lot of was what we've been hearing in the news. It was to me, a much more rhetorical argument about self-defense than it was a proper application of principles of what we should call by its name, international humanitarian law, which has as its core purpose the protection of civilians. We have had a number of civilian deaths that we can't even count at this point, at least 22,000. It may be as high as 30,000 because people, including children, are buried under rubble at this moment. What I heard today was a lot of what we read in blogs, especially legal blogs, which is, in my mind, a certain weaponization of international humanitarian law to justify military actions that subvert the very purposes of international law. And so we heard IHL being brought into an argument today about genocide, about the core leading convention of human rights and international criminal law. And I think we have to try and disentangle those two and look at the underlying acts of genocide, killing, creating conditions of life to destroy a population in whole or in part, serious physical or mental harm, the prevention of births. And what we have happening on the ground today in Gaza is a genocide. The acts, when you look at the acts compared to what you can read about in the ICJ decisions around the Rohingya, what you read when you're looking back at Srebrenica, what you can find in Rwandan tribunal judgments of the horrors of the genocide in Rwanda, the facts line up. We've also had the United States declare genocides around the Uyghurs, around the Yazidi, and I am not saying that those were improper declarations at all. What we saw is the United States trying to use this law to protect people. The facts in this case exceed the facts in those cases. So if we are looking at what the ICJ is being asked to do today and yesterday, it's to enforce the Genocide Convention and principles to prevent and to punish. So when I look at that then maybe not between South Africa and Israel, but I look at it with the duties on the United States. I feel still quite confident going into an argument on January 26th in California and saying that by continuing to provide weapons, including on the very day that the ICJ, that South Africa filed its application at the International Court of Justice, the United States sent another $150 million worth of weapons. And that's on top of the $4 billion in stockpiled weapons in Israel, which is on top of the $3.8 billion that the United States sends every year, which is in addition to the $14 billion that the Biden administration has been asking for. So when you look again at these obligations that the International Court of Justice has clearly laid out in case after case, I think that there is no doubt that the International Court of Justice will find that there are breaches of international law and that convention has been breached, and that those obligations extend to all countries and especially all member states for the Genocide Convention. How it's implemented, I agree, there are some questions, but what the lesson for all states is to stop sending weapons, to stop providing support. I don't see how that can be reconciled with complying with your duty to prevent genocide.
Well, Jenna, a few thoughts about, now I put my lawyer hats again. I think the analysis of Giulia makes perfect sense, but the court will have to justify, I think, to the public why it won't call for cessations of hostilities. I know legally it's a different situation than Ukraine, but in public, it will be that it called in Ukraine, but it didn't call in Palestine. So what hangs, I think, at balance is the reputation of international law. The judges at the International Court of Justice has an opportunity to save what's left, if any, credibility of international law in this proceedings. And I think they will also think of that. I agree in terms of jurisdiction, it's clear the court has jurisdiction. I don't think there is doubt there. I'm almost sure the court will rule positively on provisional measures. The question is which ones, because there's several demands. I think most of them are, in a way, low-hanging fruit. For example, calling for investigative bodies or commission of inquiries to enter. This goes without saying. The court will say yes. Allowing humanitarian aid, the court will say yes. So the question might be only on cessation of hostilities, and there will be, I think, it's a very interesting legal argument. So I would be interested to see how the court will justify it, especially that I think this is a different situation. And I think, if you allow me, I want to touch a bit on this, because there was a question about the repercussions and the consequences of this ruling. And I think we're already seeing it. We don't need to wait for a decision. The moment South Africa started this, Israel took a few steps. Netanyahu went on TV, say we have no intention to reoccupy Gaza. We have no intention of forced displacement. So you see, the law works. And that's why Israel has always been against any legal battle. As a matter of fact, there hasn't been once, or at least one, legal confrontation between Israel and Palestine that Palestine did not win. This is a fact. And that's why Israel and its allies will speak about peace, security, but not about justice. Because justice is harmful to Israel. Because the Palestinian cause is a cause of justice. And they seem to forget what Benjamin Franklin said at Nuremberg when he was persecuting Nazis, that, and I quote, "There can be no peace without justice, no justice without law, and no meaningful law without a court to decide what is just and lawful under any given circumstance." End of quote. That's how civilized nations resolve their disputes. If, as the West claims, Israel, quote unquote, only democracy, or it can ever get close to the term democracy, then why doesn't it go to court? What Israel is afraid of. So I think also certain things will have to be discussed at this ruling. For example, I agree, Giulia, I was really surprised that Israel's legal team used political rhetoric at the court, because the court knows that certain terms don't apply here. For example, invoking rights of defense, the legal regime that governs rights of defense is Article 51 of the United Nations Charter. This very court in 2004 said it's irrelevant here because Israel cannot invoke the rights of defense. And the law is logical. If you allow me to explain a bit why Israel cannot invoke it. The rights of defense is there for states against attack, as Julia said, coming from another state, not from armed state or armed groups. And after 9/11, if we were to submit to the, I think, opinion that enjoys little support, that Israel's or any state has the right to defend itself against armed group, absolutely, definitely, states don't have the right to self-defense under Article 51 against territories they occupy, because the law gives the occupied people the right to resist. So the law is logical. It cannot give the occupied people the right to resist, but give the occupying power the right, quote unquote, to defend itself, right? So if Israel wants to invoke the rights of defense under Article 51, it has to end its occupation. As long as the occupied Palestinian territories are occupied, Israel cannot claim the rights of defense. Same goes, for example, the attempt to paint any Palestinian resistance as quote-unquote terrorism. The court and its judges in multiple occasions, several of them have written about this, that the term terrorism is an ambiguous term that serves no legal purpose, and that is a term used politically by states against violence that they disapprove of. The court doesn't look at this or even bother to consider it. It's political rhetoric. It has no place in a court of law. And I think the Israeli team, I don't know what was the point of using it. I'm concluding. Also, October 7th, there was this attempt to paint October 7th as an illegal act. And I think the South African team did a great job to put things into context. We can't pretend that history starts on the 7th, nor can we, and nor should we, condemn or pretend that any attack in its totality is illegal. But when we talk about Israeli strikes, we talk about the technicality of IHL, whether a certain strike was proportionate or not. No, the right to resist the occupation is right there to the Palestinians. Any attack against the military army is permitted under international law. Nobody can take this right from the Palestinians, but no one on earth, neither a Palestinian or an Israeli, has a right to attack a civilian. Who's to decide that? Is a court. Guess which court has jurisdiction? It's also here in The Hague, the International Court of Justice. Well, Palestinians joined the International Criminal Court, the ICC. The Palestinians joined the ICC, and all Palestinian factions, including Hamas, signed a document agreeing on the court's jurisdiction. So you have, quote unquote, Israel and West considered, quote unquote, terrorist organizations agreeing to go to court, and, quote unquote, the only democracy in the Middle East refuses to go to court. I'll let you to contemplate that thing.
There is a huge difference between the wall. It was advisory opinion. It wasn't like this case between two states. So actually this has more powerful implementation. It doesn't mean that we really are just waiting to the ruling, because it can, even if they rule positively on the provisional phase, we don't know how long the main case will take and what will be the outcome. And this is why, for me, it's very important the kind of work that Kate is doing on the local levels in each state. And this is also needed, not just in the United States, it's needed here in the UK, in Spain, in France, in all these countries that Ahmed was describing, that they're, and you know what makes me very worried to see Mr. Barak sitting in the panel. I know his legacy. He's the father of the terminology of we are a democracy fighting terrorism, so we have limitation. I mean, Israel were for 7 decades trying to redefine the international humanitarian law and human rights law according to their interests. And this is what we need to stop as collectives, as human rights activists around the world, if we believe in equal human rights for everyone, everywhere.
The distinction, between committing genocide and failure to prevent. So here the allegation of South Africa is that organs of the State of Israel have themselves committed genocidal acts that are listed in Article 2 of the Convention. So this is conduct that is attributable to Israel under the rules on state responsibility for internationally wrongful acts. Failure to prevent, it could be that there is genocidal conduct that is carried out by actors that are not organs of the state or whose conduct is not attributable to the state of Israel. For example, who are not acting under the instructions or the control of the state of Israel. But still, when information becomes available that there is a risk of genocide being committed, then state parties to the Genocide Convention have the obligation to prevent. And this is an obligation that rests not just on Israel, but on all state parties to the Genocide Convention. So all of the other actors that we've been talking about also would have the obligation to prevent. And it's not an obligation that can be discharged simply by issuing vague reminders to the parties to the conflict that they should abide by their obligations under international law. It's unfortunately a gray area, like what exactly is required for states to do to ensure respect, but it's definitely not an obligation that is discharged by reminding Israel that they have to abide by their obligation, or they should do everything within their powers to minimize civilian casualties. That's not enough.